Welcome everyone. I'm Russell Alexander. I've been a lawyer with the team here at Russell Alexander Collaborative Family Lawyers for over 20 years. We help families with separation and divorce. Without further ado, let's get into today's topic. Wife loses latest bid to preserve and use dead husband's sperm. In a heart-wrenching, difficult case from the British BC Court of Appeal, the key issue was whether the sperm of a recently deceased husband could be removed from his body after he died and used by his wife to create embryos, even though the husband had not given his prior consent while alive. The couple had a long-term relationship and had recently had a child together. They'd been planning to add to the family to give their child a sibling. But the husband's unexpected death, the wife now wanted to use his sperm to create embryos through assistive reproductive technology and give birth to children for whom the husband would be the biological father. The court introduced the narrative of the wife's agonizing journey through the court system with these words. This is a very sad story. The parties were happily married at the time of the husband's sudden and unexpected death. And everyone agreed that the parties wanted to have more children, at least one sibling for their first child. The antagonist in the story? The Federal Assisted Human Reproduction Act and its regulations, which prohibit the removal of human reproductive material from a donor without the donor's prior informed written consent. The court continued, as is probably true for 99.5% of the Canadian population. Neither the husband nor the wife considered what would happen if one of them died. They did not want to turn their minds to the possibility of using respective reproductive materials after one of them had died. However, for the purpose of the analysis, the Court of Appeal accepted that the husband would have consented to the use of his reproductive material had he considered it. But he did not actually consent in accordance with the plain statutory regulation of the Federal Act. And that was a big problem. Immediately after her husband died, the wife brought an urgent after-hours application to the court to allow her to remove his sperm and having it stored in an IVF clinic. She also wanted a clear court order allowing her to create embryos for reproductive use. Recognizing the timeliness of this urgent request, a lower court granted her request temporarily pending a further court order. Given the importance of the outcome to the general public policy around the use of human reproductive matter, the matter was then attracted the input of various federal and provincial government ministries, who were allowed to make submissions at a later full hearing. If you're enjoying this video and find it helpful, you can give it a thumbs up or leave us a comment below. At the next stage before the second lower court judge, the wife unfortunately did not succeed in getting the order she wanted. The wording of the legislation was clear. The husband's reproductive material could only be used if he had given prior informed written consent. There was no ambiguity in the language, no loopholes, and no exceptions to be resorted to. As the Court of Appeal said in the chronology, very reluctantly, and recognizing the terrible tragic circumstances, the lower court judge dismissed the application and terminated his interim order preserving the sperm. However, he stayed his own order to permit the wife to appeal. Not surprisingly, the wife did appeal further. Unfortunately, the appeal court was likewise unable to rule in her favor. The court noted that the legislative scheme was validly enacted by Parliament and reflected a clear policy-based choice that favored individual autonomy and control over one's body. Even the fact that the moral and ethical dilemmas raised by the new reproductive technologies, the legislation was clearly worded and unequivocal, and was subject to straightforward, well-established rules regarding statutory interpretation. For the wife to be entitled to use his sperm for reproductive purposes, the husband would have to give prior written consent before his death, which he sadly did not do. Regrettably, the wife's appeal was dismissed, but the Court of Appeals stayed its order to give her 60 days within which to consider launching an appeal to the Supreme Court of Canada. At least at the time of the writing of this blog and our video today, it appears that the wife did not avail herself of that option. To learn more about this case, you can read the full article linked in the description below. Please give us your thoughts and comments below. Once again, if you like this video, please give us a thumbs up to let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.